For the reasons set out in the judgments which I'm handing down this morning, the appeals are dismissed.
Bail in the matter of Joanne Properties Limited and Moneything Council Limited another.
Yes, Ms. Kingham. Just before you begin, can I say that we are likely to be asked to observe a minute's silence this morning at 11 o'clock.
Grateful for that indication, Your Lordship. Shall we keep track of the time, or will there be...
There should be an announcement that comes over the tannoy, but if not, I will try and keep an eye on the time. I should perhaps also tell you that we've read the skeleton arguments and the judge's judgment.
I'm very grateful. Confirm that those are the replacement skeleton arguments that
yes.
were filed. In which case, then, would it be helpful for me to set out anything by way of background, or shall I dive straight into my submissions?
Well, set out the background if you think it's necessary, but it seems to me that what we're focusing on is a relatively small clip of correspondence and attendance notes passing between the various solicitors from late May to mid-July.
Yes, absolutely. In which case, what I would propose to do, if I may, is to very briefly start by setting out a summary of the relevant legal principles to be applied. I say very briefly because I don't think there's much dispute as to what those principles are, but important nonetheless to have regard to them briefly. There is potentially one area of potential difficulty, which is the extent to which the court should have regard to matters arising after the 11th of July 2019, which is, of course, the date of the alleged settlement agreement. But if I may, I'd touch on that to that point in the relevant correspondence. So if I may start just by briefly setting out a summary of the law and then moving quickly thereafter to the correspondence itself in tab 9. There are, of course, a number of authorities in the bundle, not least Cohen and Nestdale, as identified by my Lord Justice Lewison in giving permission. The combined effect of those authorities, as well as a number of others, is very succinctly summarised in the Bieber case, which is cited by my learned friend in his skeleton. And since I don't think I could more concisely or better summarise the relevant principles than the judge does.
That's Judge Pelling's judgment, is it?
Judge Pelling's judgment, yes. Paragraph 14 of that judgment, tab 8. Tab 8 of the authorities bundle at page 100.
Yeah.
And he sets out there 8 legal principles to be applied in cases such as this. And in my submission, that's an accurate summary of the authorities and the principles to be applied in this case. Without reading them all in full, the headline points of each, the first there, 14 paragraph Roman numeral I, whether the parties have reached a concluded agreement is to be determined objectively by considering the whole course of the parties' negotiations. Then moving down to generally the subjective state of mind of a party to negotiations, and thus any subjective reservations that have not been communicated to the other party to an alleged agreement are irrelevant, and evidence of their existence is inadmissible. Over the page 3, if on an objective appraisal of the parties' words and conduct, the parties intended to conclude a legally binding agreement, the fact that certain terms of economic or other significance had not been agreed does not prevent it being concluded that the parties have concluded a binding agreement. Then 4, where the parties wish to ensure that a contract otherwise capable of being made orally is only made in a formal document, the parties may ensure that it is so by expressly stipulating their negotiations will take place subject to contract. 5, it's not essential that there be an express stipulation, if nevertheless that was a mutual understanding of the parties. 6, whilst negotiations are being concluded subject to contract, whilst whilst negotiations are being conducted subject to contract, are most commonly encountered in transactions concerning land. The rule is capable of applying to any contractual negotiation. 7, whether there was a mutual understanding that negotiations would proceed on a subject to contract basis is a question of fact in each case. And finally, 8, even if the parties have initially agreed to proceed subject to contract, it is open to them subsequently to agree, either expressly or by necessary implication, to remove that qualification or waive that stipulation. However, whether the parties have so agreed is a question of fact that needs to be approached with care, since the court should not impose contracts on the parties which they have not reached.
And are the authorities in footnote 582 in Chitty, those are Sherbrooke and Dipple and Cohen and Nestdale, are they, plus the Savannah and case?
Yes, I believe so. Although Cohen and Nestdale isn't specifically cited by the learned judge in this case, it's clear that Principle 8 is that principle, expunging or waiving the subject contract qualification. If perhaps I could just amplify that final principle at subparagraph 8, relating to the removal of the subject contract qualification by necessary implication. And by doing so, if I could ask the court to take a very quick look at tab 3 of the which is Cohen and Nestdale, and in particular the judgment of, or Justice Cumming-Bruce at page 20. And the reason for referring to this particular passage at letters C, E, and F in particular is that there is a distinction drawn between reasonable implication of such a term and necessary implication. And in particular at little f, his lordship was considering whether it was reasonable to imply a term that the parties were no longer negotiating on a subject to contract basis. And he says, well, if I could ask the court to read that final paragraph at little f.
Well, it would, to my mind, be perfectly reasonable.
Yes, Millie.
Yeah.
In some senses, I suppose it's a common sense point, but it's just stressing the importance of it being necessary implication as opposed to one reasonable interpretation of what was agreed. If I may then, I would move directly to the correspondence unless there are any specific points arising on the law as stated there.
No, except I think that the question about the subsequent conduct is particularly relevant here because the judge seems to have placed some reliance on the delayed response following the change of, or following the sending of the draft consent order, that obviously being conduct after the agreement was, according to one party, concluded.
Yes, in fact, both my learned friend and I, to a certain extent, well, certainly myself, rely on events that occurred after the 11th of July. The appellant relies on the fact that the draft terms, when they were sent on the 24th of July, were headed subject to contract. And then the learned judge below, of course, as you've already indicated, relied to a certain extent on the significant delay. That is a point which you will have seen. There is some, it would seem, incongruity in the High Court as to the correct approach to be taken. And in fact, my learned friend, I think, deals with this point rather better than I do in his skeleton, at least in more depth, where he sets out the conflicting authority. So perhaps it would be helpful if we turned to his skeleton at tab 15. And these are the points made starting at page 189, his paragraph 17, and then over the page at 18 and 19.
You accept those as accurate and accurately setting out the law?
I do, my lady.
Well, how does that sit with cases like, is it von Hatzenfield and Wilder, which say you must look at the whole correspondent, you don't just stop the clock when you've got an apparent agreement?
Well, perhaps I should clarify. When I say that I agree with my friend on his submissions at 1719, I mean specifically in that he sets out a potential difficulty in relation to these authorities. There is some tension between them. The appellant doesn't take a particular stance on whether or not the court should be permitted to examine post-agreement conduct. Either that evidence is admissible and relevant, in which case the appellant says that the letter to the court at page 131 of the core bundle headed subject to contract, and the subsequent letter sent enclosing the draft terms on the 24th of July, again headed subject to contract, and that was evidence of that qualification, or that evidence is inadmissible and irrelevant, in which case the appellant nonetheless says that it ultimately doesn't matter too much, because on the facts of this case, it's clear on the evidence predating the 11th of July that the subject's qualification was, subject to contract qualification was nevertheless in play at that date. So without taking, if I may be permitted, as it were, to sit on the fence somewhat, I can offer one tentative submission, which is that it would seem relevant to take into account the whole course of dealings between the parties, including potentially conduct that takes place after the date of the alleged agreement. And it's clear that in some cases that will be necessary, specifically, for example, in the case of a Cohen and Nestdale situation where we're considering expunging the qualification, then clearly in that situation it has to be relevant to consider what happens after the date of the proposed agreement. But I accept that evidence of post-agreement conduct should be limited, of course, to the interpretation of what happened at the time of the agreement.
Well, I think there are two separate questions. The anterior question is, has there been an agreement? And for that, my understanding is you look at the whole of the correspondence, both before and after the particular letters which are said to constitute the agreement. If there is an agreement, then yes, certainly, post-agreement conduct is not relevant. But we're concerned with the first question: has there been an agreement?
Yes, Lord, I'd suggest it's probably common sense that the way in which the parties interact after having come to what is said to be an agreement can be evidence as to whether or not they at least believe themselves to have come to an agreement. There's some issue there with the subjective interpretation and the objective interpretation of the matters giving rise to the agreement. But it can certainly be indicative in aiding in interpretation of whether or not an agreement was reached in the first place. But it's something that I suggest probably needs to be approached with some caution to make sure that it is, as I say, reflective of the objective agreement between the party rather than just their subjective understandings of it.
Yeah. Yes, I mean, looking at what Mr. Justice Lewis said in Newbury and Sun Microsystems, he's quoting from Mr. Justice Males, and this is at tab 7. And the first point that he makes in the quotation at paragraph 14 is in deciding whether the parties have reached agreement, the whole course of the parties' negotiations must be considered. And then quotes from Panyan and Feed, Principle 1, in order to determine whether a contract has been concluded in the course of correspondence, one must look to the correspondence as a whole. So I'm not sure that Mr. Justice Lewis is right in paragraph 27. Anyway. Unless he, by subsequent conduct, he is talking about something outside the correspondence.
Difficulty with subsequent conduct, when looking at whether or not a contract has been agreed or concluded, is that one or other of the parties may be mistaken about whether or not they've concluded a contract, and therefore their subsequent conduct may be misleading. Is that why you are suggesting that one needs to be cautious about looking at subsequent conduct?
Yes, well, it's really another way of putting the subjective versus objective question, I think, because it's quite possible to contract well in certain situations without perhaps intending to. I mean, I realise that in some ways that itself poses difficulty, but it certainly seems to be the case that there are a number of reported authorities where it's not clear, or at least it's said not to be clear between the parties that they've entered into an agreement, and nonetheless they've held to be. And it's important for that reason that an objective interpretation is applied. What do the communications on their face demonstrate to the objective observer? And subjective evidence of what each party understood, if they weren't expressed and written down in a way that any other objective bystander would understand, that those subjective reservations or understandings don't properly form part of the agreement. And so when looking at post-agreement conduct, I think perhaps that there may well be a distinction to be drawn between conduct and correspondence, especially if the correspondence is directly dealing with those express terms or what was understood in the previous agreement. But again, one runs into difficulty very quickly if one of the parties is essentially trying to backstep and retrospectively apply an interpretation or an understanding to what was said, then clearly that's not desirable. And so for all of those reasons, that's why I say one has to be cautious when looking at post-agreement correspondence and conduct. And
there's a whole other line of cases that deal with agreements to agree, and when a contract has been concluded which aren't dealing with the subject contract, in which cases the conduct that's relied on is usually that the parties have started performing their obligations, and what that says about whether they thought they were bound or not. But anyway, let's not complicate matters.
It was a similar sort of situation, I believe, if I remember correctly, in the RTS and Muller case, in that RTS had provided draft terms and then before, and that they were provided, including a provision that everything was to be agreed subject to contract. But before any formal agreement was concluded, RTS started installing the production machines at Muller's site. And that was something that was held by the court to be relevant in determining whether the subject to contract label had been waived. Because clearly the parties were agreeing, at least on some basis, to continue with the sale, the provision of those machines, because they had in fact been installed.
Yeah.
Yes, so at page 82, behind tab 6 of the authorities bundle, paragraph 86.
Paragraph?
86.
Yeah.
And the first point remains. Had the parties agreed to be bound by the agreed terms without the necessity of a formal written contract, or, put another way, had they agreed to waive that requirement? We have reached the conclusion that they had. The circumstances point to the fact that there was a binding agreement and that it was not not on the limited terms held by the judge. The price had been agreed. A significant amount of work had been carried out.
And there was a variation.
There was.
And one only needs to adjust those facts very slightly to reach a contrary conclusion. So, for example, in many cases like this, you would have a letter of intent, and people would be prepared to go ahead on the letter of intent, and that would remove the implication.
Yes, Lord, I believe there was a letter of intent in this case, which was the letter that originally included the draft terms that RTS was relied on. But it was subject to an expiration date. So I believe that the letter of intent was only supposed to apply for a period of 4 weeks, after which it was envisaged that there would be a binding agreement. And that date came and went, and there was still no formal agreement. With court's leave, then, what I would propose to do is to take a look at tab 9 and to the relevant correspondence. I'm afraid I will try not to be too cumbersome in my approach, but it is necessary to take the court to a number of the exchanges in the correspondence. And I should clarify just before I do so that in my skeleton, I've focused on 3 pieces of correspondence in particular, what I call email 1, email 2, and email 4. That is the offer on the 11th, the acceptance, and then the draft terms on the 24th. And in all of that very key correspondence, key in my submission, the phrase subject to contract appears. However, my learned friend takes issue with that focus, which he says is too narrow and contrary to authority, at paragraphs 15 and 16 of his skeleton behind tab 16, or 15 rather, of the core bundle. he says in particular that it appears to be the appellant's case that the court must look only at the exchange of emails which took place on the 11th of July, and to a limited and partial extent the conduct thereafter. Importantly, the appellant does not allege that the negotiations between the parties were taking place subject to contract prior to that date. He then goes on to say, at paragraph 16, the approach is flawed and contrary to authority, that the authority cited demonstrate the court must look at the whole course of the negotiation. The exchange that took place on the 11th of July was not the start of the settlement discussions, rather it was the conclusion of it. I do not disagree with the approach that he sets out there, and I similarly do not disagree that the exchange that took place on the 11th of July was not the start of the settlement discussions, rather it was the conclusion of it. That is correct, and it has never been the appellant's case that the subject contract qualification was introduced for the first time, or the first relevant time, on the 11th of July. Rather, the approach has been to focus specifically on the 11th of July, because on the face of the offer and on the acceptance and then subsequently on the terms themselves, the qualification was writ large, so to speak, quite expressly over the face of it. But that isn't to say that it was the first time it was raised, or that that was when the qualification first started to apply. And so I would like, returning to tab 9, as we move through this.
Well, Mr. Irving introduced it on the 29th of May.
Yeah, precisely. In fact, it had been asserted by both parties prior to the 11th of July and on 3 separate occasions. On the 29th of May, then on the 13th of June, then on the 21st of June, and then finally, crucially on the 11th of July twice, both in the offer and in the reply, and then for the 6th and final time on the draft terms that were sent on the 24th. Beginning at page 98 behind tab 9, this is an attendance note dated the 24th of May 2019. It was a call between the solicitors for both sides. And there is no great significance to this letter. The main point of it is that, of course, it forms the starting point for the remainder of the discussions. The main thrust of this call between the solicitors seems to have been to identify as a basic starting point how much had actually been lent to the appellant, which I appreciate may seem like a very basic question, but there was in fact a dispute about how the rolled up interest that was payable on the first year should form part of the principal. And so if we turn over the page to page 99, we see 2/3 of the way down the page where it says David said that he felt if we could get to an understanding on the sum that had in fact been lent and that had interest calculated on it, we could then turn to the amount that had been ring-fenced. And then moving down the next paragraph, final line of that paragraph, first of all, we needed to get to the basis of the figures we were talking about. RMI being Mr. Irvin agreed. So at this point, settlement proposals have yet to be made, and this is, as I might phrase it, a scoping call, and they're trying to get to the basis of what exactly has been lent, and in the hope that that figure will then provide the foundation for later settlement discussions. And that is clear on page 100 at the final paragraph. Second line towards the right-hand side, he wanted to see if we could agree the basis of the calculation first. Moving then swiftly onwards to page 101, and I won't take your lordships to every single document in behind tab 9, I promise, but there are a number to go through. Page 101, the email dated the 29th of May, here Mr. Irvin provides some figures in an attempt to resolve the issue that was raised in that previous call about how much exactly had been lent to the amount of interest to be applied to it, and that is at the bottom. And as my lord has already commented, this is the first time that the phrase subject to contract is used, and it's the appellant's case that this was the assertion or the erection of the subject contract umbrella over this.
Attention please, attention please. This is the Security Control Office. You are now invited to observe a 2-minute silence to mark the anniversary of Armistice Day. Thank you.
Yes, Mr. Kingham. Got to the 29th of May, page 101.
Lord, yes. What I was in the process of saying was that this is the first time the subject contract label is used, and it is the appellant's case that this was the time at which the umbrella was erected over the negotiations that they were to be held subject to contract. And it's relevant in that regard that this is the first time that specific numbers seem to be advanced as the amount and calculation, and then these numbers then sparked a chain of correspondence, which is included in tab 9.
Yeah.
And moving over to page 103, the email dated the 7th of June, we have a without prejudice email from Mr. Goldberg, and the second full paragraph down, Mr. Goldberg says that he is, in the circumstances, I am instructed to propose that we compromise your client's claim against mine by way of an agreement of the total amount due to them being £613,000. My client then proposes that each side bear their own costs. Thereafter, we can work out the mechanism and all logistics of how this applies. So this is an offer in some ways, but it lacks a significant degree of precision. It's not even really an amount. It doesn't relate to the ring-fenced sum specifically, but it provides that an offer for the starting point of the negotiations, as had been identified in the original call evidence by the attendance note at page 98. Moving then to page 106, the email the 12th of June 2019 from Mr. Irvin, and at the bottom of that page under heading 3, without prejudice, there is essentially, in my submission, what is happening here is Mr. Irvin is setting out the strategy for these negotiations, the framework, how they are going to proceed. So he says, on the second line of that paragraph, however, to cut things short, I think it might be of assistance if you could put a figure to my client that your client would accept in settlement based upon their suggestion of £613,000, in respect of which I fully and unequivocally reserve my client's position, but that figure can then form the basis of a discussion between you and I so that I can understand it. Before I put it to Moneything MT as a formal offer, we can then agree a mechanism by which that figure, or whatever figure is agreed, can be released by the ring-fence sums or otherwise. And breaking that down, I suggest that contemplates 4 stages, so to speak. First, a figure is to be put that Joanne Properties would accept in settlement, and that is to be calculated on the starting or principal amount of £613,000, although significantly, Mr. Irving is quite clear that his client's position is still very much reserved on that point. Second, that figure then forms the basis of inter-solicitor correspondence and negotiation. Third, and only at that stage, is a formal offer put to Moneything. And then fourth, finally, the mechanism for releasing the funds from the ring-fence sums will be agreed. And whilst there's no mention of the subject contract qualification in this email, I'd suggest that this is consistent with Mr. Irvin reserving his client's position unequivocally. I'd suggest that's consistent with the understanding that these negotiations were proceeding on a subject contract basis, even though it's not direct evidence of it. Moving on to page 108, an attendance note dated the 13th of June. The first page is mainly discussion between the solicitors as to the merits of the case itself. And at page 109, the top paragraph, halfway down, my client had already received the sum of £645,000 in repayment of the loan. What remained were the ring-fence sums of about £140,000. And this is, moving down to the second paragraph, having discussed the matter with my client without prejudice and subject to contract, RMI said that his client was considering offering the sum of £60,000 to be released from the ring-fenced sums. And this is the first offer regarding the division of assets of the ring-fence sums specifically. And as Mr. Irvin records in his note, that offer was made explicitly subject to contract. This being the second time now that Mr. Irvin has asserted the subject to contract qualification in correspondence. Down the page, about 2/3 of the way down, the call ended amicably. Mr. Goldberg would take back what he said and to reiterate the offer in principle was that, and he then sets out terms there. And I would suggest that there is some significance perhaps to be attached to the fact that Mr. Irvin in his own note described it to reiterate, as he said, that the offer was in principle, and I'd suggest that that's consistent with the basis of the negotiations being subject to contract. And furthermore, I'd suggest that that offer, as he sets out in those 5 numbered paragraphs there, then provided further detail and the skeleton of the remaining negotiations between the parties after this date. The only question remaining was how much each party would get from the ring-fenced sums. That's his number 3 there.
Well, I thought your case was also that there was some question. Here it says, number 1, the claim is dismissed. But isn't part of your case that actually the consent order that provided seemed to require the dismissal of other related claims as well?
Yes, my lady, that's quite right. There was and still is another claim in, now in the Chancery Division. But at the time in the Queen's Bench Division. If I may then move on, I will skip over page 110 and go directly to page 111. And it would seem, at least from my reading of it, that page 111 was an attachment to the email at page 110. And here we have now a more formal offer, certainly drafted in a more formal manner. And it's made on substantially the same terms as that set out in the attendance note, to which I've already referred the court. The main difference is that there is now provision for the defendant's costs in paragraph 3. Pausing there, the learned friend notes at paragraphs 22 and 23 of his skeleton that the parties described this offer as a Part 36 offer in later correspondence, and he goes on to say that a party cannot place any subject to contract qualification on a Part 36 offer. So in response, very briefly, I'd submit that, first off, this wasn't a Part 36 offer. It quite explicitly did not comply with CPR 35.51b, in that it didn't state itself expressly to be a Part 36 offer. And on that note, it may be of some limited interest that the solicitors for the respondent have in fact provided 2 drafts of this letter. There is this draft, and then there is also the one that appears in the supplementary bundle, at page 33 of the supplementary bundle.
Is that the one that was attached accidentally to?
It was indeed. So that is behind tab 3. At page
What did you say about this? Is the file copy?
Well, it's not entirely clear what this is. Mr. Irvin says in his witness statement that this was a draft of the letter, but that it wasn't sent.
Right.
So just before I take you to his witness statement...
It's dated the day before.
Yes. I'm grateful, Lord. The main point to note here is that this appears at page 33, does expressly state it to be a Part 36 offer.
Yeah. Is it a Part 36 offer? Can you quantify costs in a Part 36 offer in the way that this letter does?
Well, I must confess that that's not a point that I've considered. It certainly, in any event, was an attempt to comply with the requirements of Part 36.
Well, if it insists, I don't suggest that it was a Part 36 officer, and your lordship's quite right. You can't quantify costs in that manner and comply with Part 36.
Great, well, friend. In which case, at page 111, behind tab 7 of the supplementary bundle, paragraph 8 of Mr. Irvin's third statement, the second line of paragraphs 28 and 29 of Mr. Sekar's statement.
Sorry, I'm behind you. I've lost the reference. Where are we?
I'm in the supplementary bundle behind tab 7.
Tab 7, yes.
At page 111.
Yeah.
Paragraph 8 at the bottom of the page. And this is where Mr. Irvin explains, to some extent, the 2 drafts.
Yes.
He takes issue with a letter dated 18th of June 2019 at page 18 and states that this was not an accurate copy of the letter which was in fact sent. That is correct, and I apologise for the error in production of this part of the exhibit. The letter is in fact a draft and was included in my first statement by mistake. But he doesn't provide any further explanation. And I don't suggest that any particular inference should be drawn from that, but it is perhaps relevant that a previous draft expressed itself to be Part 36 offer, and then the draft that was actually sent did not. And
Doesn't that fall within the realms of what's going on behind the scenes that you say is inadmissible?
well, yes, I don't seek to draw any particular inference from
And
it.
the short point surely is that the letter that we have at 111 in the core bundle is not a compliant Part 36 offer.
Yes.
Full stop.
The,
Is there any other significance?
No, the only point really then is whether there is some tension between the final paragraph of the letter in which it says if this offer is not accepted and at trial the defendants achieve an outcome equal to or better than the above, then it is our intention to invite the court to make additional orders. And so the question is whether perhaps there might be some tension between making that sort of argument whilst at the same time holding that it was all subject to contract and that this wasn't an offer open to acceptance, formally, so to speak. I raise that only because the similar tension was discussed in the.
But why shouldn't it be capable of acceptance as a standalone offer, separately from the negotiations that are going on? I mean, all right, it's not a Part 36 offer, but why can't it be a Calderbank letter capable of acceptance?
Well, then the question, I suppose, Lord, is whether the letter, if it is an open offer capable of immediate acceptance, whether that then lowers the umbrella of the subject to contract negotiations, or whether it should be seen simply alongside or outside of those negotiations.
Well, it might be a separate offer made in the rain, not under the umbrella.
Yeah, absolutely. And perhaps I'm thinking in too linear a fashion then, where subject contract negotiations start and they proceed until either the qualification is expunged and a firm offer is made, or they do not. What your lordship is envisaging is that two could be going on at the same time, and of course there is I see no issue with that as a matter of.
I mean, if it had been a Part 36 offer, that would be a standalone offer, wouldn't it? Carry on negotiating without prejudice and subject to contract, but you make an offer which is capable of acceptance separately.
Well, yes, there's force in that submission.
But it doesn't mean that everything hereafter is no longer subject to contract. I think that's what you're saying.
Yes, exactly.
That you can make an offer which, if it had been accepted, would have bound the parties, but as it wasn't accepted, the subject to contract rubric is then
reinstated.
Yes.
There was a similar problem that encountered in the Goodwood Investments case. I don't know if this is a point that actually assists your lordships any further. It may be that it's not a matter that I can assist with much further, but
well, I don't think anyone's saying that this was accepted. This offer in this.
No, lady. The real relevance of it is, as you've already identified, whether it has some way of interrupting the subject contract nature of the negotiations, and then what followed afterwards was no longer subject to contract. And I may misunderstand the argument, but I was seeking at least to address that point insofar as it's raised.
Yeah. Well, we'll hear what Mr. MacDonald has to say about it, and you can deal with it in reply, if need be.
In which case, I will move on to page 113, of the core bundle, which is the email dated the 21st of June. Now, this letter is, of course, headed without prejudice and subject to contract. And Mr. Goldberg says, following our discussion last week, I took instructions as agreed, so we are both clear. I set out below the content of the email I sent my client. And then he then quotes, the bottom line is that they propose, and I understand that to mean Moneything, without prejudice, WP, subject to contract, and subject to agreeing the mechanism, the following settlement. And he sets out their four-numbered points. And in my submission, this is a significant email. First, it's the third time that the subject contract qualification has been asserted. It's also the first time that it's been asserted expressly by solicitors for the appellant. And it's also significant because the way that Mr. Goldberg breaks down the offer by reference to 3 conditions that, as he understands it, form the basis of the offer that's being discussed. First, it's without prejudice. Second, it's subject to contract. And third, it is subject to agreeing the mechanism. And that mechanism being understood, I think there's no dispute as to how funds would be released from the ring-fenced sums. And so to the extent that it might be argued that references to subject to contract or terms to be agreed and so on were references only to mechanism of release of the funds, that I would suggest that it is made quite clear here that subject to contract and subject to agreeing the mechanism are 2 separate concerns. There then followed, after this, a number of emails. They don't, frankly, materially change the situation much. Having said that the parties weren't going to engage in horse trading, what follows thereafter is a certain amount of haggling over the exact amount that is going to be released. But finally, at page 121, at the bottom of the page, there is an offer in the email dated the 10th of July from Mr. Goldberg. And as you see from his little paragraph, Roman numeral 4, he makes an offer of £72,000 to be released from the 140,000 that are ring-fenced. Now, at little Roman numeral 2, he says, I need to take instructions on the agreement you refer to below. And then he goes on, at paragraph 4, to say, I can sell a deal at 10% off the 80,000, a payment to yours from the 140,000 of 72,000. Please revert ASAP. Please note this is just trying to agree the figures. The mechanics terms are separate issues, but I don't think insurmountable. That then, however, is somewhat a different tone than what is found at page 126, which is just the following day, and it's an attendance note, again produced presumably by Mr. Irvin. And this was a call referring specifically to that email that the court has just read. And starting at the top line at the right-hand side, he, Mr. Goldberg, said he had been confused by my email stating that I had to take instructions on a firm offer. He said that the offer from JPL for 72,000 to be released at MT was an offer. RMI had misread his email. RMI understood he was hoping to sell a figure to his client. David confirmed that this was a firm offer with instructions from JPL to make to MT, and if accepted, that was the matter concluded, save that we still had to work out the mechanics. Now, that contrasts somewhat with what was said in the email, and it's unsurprising that there's a suggestion that Mr. Irvin had misread the email, because when one looks back to page 121, it is understandable that one would take the view that Mr. Irvin appears to have taken in that attendance note, because Mr. Goldberg says at page 121 that he needed to take instructions at little Roman numeral 2, and then that he was trying to sell a deal at 10%, and further on at little Roman numeral 4, that he was just trying to agree the figures. So that certainly didn't, at least in my submission, doesn't come across subjectively as a firm offer, but nonetheless, in the attendance note at 126, it is
Well,
confirmed.
then after that, they have on the 11th of July this exchange on 123, at which point they think, well, one of them thinks, well, it'd be quicker if I pick up the phone and speak to him to work out if there's an offer or not, because we seem to be talking at cross purposes.
Quite so, maybe, yes. Yes, and at the top of the page, Mr. Goldberg saying, I made an offer, I assume it's been rejected. It's clear that they are talking at cross purposes to a certain extent. And then there seems to have been some clarity in the telephone conversation at page 126. And the respondent now places emphasis on the fact that Mr. Irvin made a note that this was a firm offer with instructions from JPL to make to Moneything, and if accepted, that was the matter concluded, save that we still had to work out the mechanics. And what I say in response to that is, first, of course, this is a note, not a transcript, and that I am sure it is a very faithful note, but nonetheless, it doesn't have all that was discussed between the parties, and it is difficult when trying to interpret this single phrase what exactly it might mean. It is, in my submission, open to a couple of interpretations. Perhaps, yes, on one hand, it could mean that the parties were no longer negotiating subject to contract, or on the other hand, it could just as well mean, and in my submission it did mean, that there would no longer be any substantive issues between the parties to this dispute. There would no longer be any real obstacle between them preventing settlement, but that it shouldn't be understood as waiving expressly any requirement that it still be put into writing. And furthermore, I'd suggest that this statement on its own, again, it isn't sufficient basis on which to, by necessity, imply that any subject contract qualification, by this point reiterated 3 times, had been expunged.
But supposing, contrary to your argument, that it had, 72,000 was not accepted, and an increased offer was made later in the day, subject to contract.
Yes. Yes. Well, what we see is that at a number of times, you might argue that the umbrella has been closed, so to speak, whether by that quasi Part 36 offer or by this conversation. But each time after the interrupting event, or the purportedly interrupting event occurs, there is then a reassertion of the subject to contract label. And that's why, as I say, it continues to crop up throughout this correspondence, right up to including the 11th of July on the face of the offer itself. And perhaps that's why in the court below and in my skeleton I focus so much on those emails on the 11th of July, because they contain the offer and the acceptance, and it's actually written on the offer that it's subject to contract. But the criticism has been made that that is too narrow a focus, and so when one goes through, in my submission, each of these exchanges, there is, as I say, a continual reassertion, reapplication of the subject contract label.
Yeah. So the sequence of events seems to be, there's a conversation in which Mr. Goldberg offers a 72,000. Mr. Irvin says he's got to take instructions. Mr. Irvin then comes back later in the morning, subject to contract, and says that Moneything will accept 75,000 rather than the 72 that Mr. Goldberg has proposed.
Yes.
And that is what Mr. Goldberg then agrees to in his email at 2:30, page 130.
Yes. Yes. So the email, which I have called email 1, at page 127, is in reality a counteroffer.
Yeah.
And that is a fresh email chain started by Mr. Irvine.
It is, yes. And I made the submission, I believe, in my skeleton that presumably it was Mr. Irvine who, as a solicitor, would or should be taken to have known the meaning of the phrase, who typed that.
Well, he typed it, yes.
Right.
Then moving over the page, page 128, pause just briefly to note this is an email that was sent by Mr. Sekar to Mr. Goldberg the same day. Mr. Sekar, you will have seen as director of my client. There are 2 points to raise here. First, in my submission, I'd say that this is not properly relevant evidence because it wasn't communicated to the solicitors for Moneything. And to that end, there's no need to take your lordships to it unless it would assist, but paragraph 14.2 of the judgment in Bieber, which referred to subjective reservations, thoughts not communicated to the other side, not being relevant. And I suggest it's not helpful in interpreting what occurred between the parties. However, in any event, I don't suggest that it's inconsistent with the appellant's case, because Mr. Sekar says, please let me see the settlement terms. But in any event, my Lord, I wouldn't suggest that it's particularly helpful. There is then at page 130 the email from Mr. Goldberg responding. This is the purported acceptance. Well, it is an acceptance, but the appellant would say an acceptance subject to contract. 2 points to note there. The first is that, of course, subject contract remains in the subject heading to the email. And it, of course, is quite possible that Mr. Goldberg may have just hit reply. But the point that he did so without expunging the qualification. And it was a qualification that had now been asserted 4 times in correspondence.
You can't expunge it. If an offer is made subject to contract, you as the acceptor can't then decide unilaterally that you're going to accept it in a way that binds the offeror, can you?
No, my lady, I wouldn't suggest that you could. I mean, I suppose the most you could do is purport to accept it on a non-subject contract basis, which in reality would just be a new open counter-offer. The other point to note is that Mr. Goldberg says, my client's counsel is away until next week. On his return, I will liaise with him and put a proposal to you to achieve the desired end. And you will have seen I make a point of my skeleton argument that in order for something to be a proposal, it must be capable of rejection. Otherwise, it's a demand. The final piece of correspondence to which I'll take course is at page 131, which is a letter the same day, or an email rather, to the court. Now, this is the first time when the question about post-agreement evidence becomes relevant. There's already been some discussion of that. I would only say in relation to this particular letter that this is as close to contemporaneous as it could possibly be. It's only 6 minutes after the agreement was alleged to have been entered. And of course it copied in Mr. Irvine as well. And points are made in my skeleton about it, that Mr. Goldberg uses again the phrase that it was an agreement in principle, or that in his 3rd paragraph, in the circumstances, I'd be grateful if you could note the court file accordingly. The next thing will hopefully be a settlement consent order, i.e. it wasn't clear that there would be a settlement consent order.
Yeah.
That was all of the correspondence which I'd intended to refer you.
This letter to the court, my understanding was there wasn't a particular pending hearing that was then vacated because of this. Is that right?
There is some reference in the papers to Mr. Goldberg having received a listing notice for what I think was the first case management conference. I did see that in one of the attendance notes, but it wasn't an immediate hearing. It was some time off. I'll see if I can find it.
Well, don't worry.
In any event, it wasn't an imminent hearing. The reply, from memory, was served in June 2019. It appears in the supplemental.
Milady, if it assists at page 121, it's, I think, my learned friend's referring to a reference in Mr. Irvin's email in which he says the court's, it's halfway down on page, the first paragraph on page 121, MT will not extend the time to accept the Part 36 and make the point that the court directions now require us to prepare cost budgets and agree case management directions. I anticipate that's the point that my learned friend was doing.
I'm grateful to Mr. MacDonald for that. It wasn't, in fact, what I was thinking of, but that is a helpful indication that I do think there was reference to a listing notice having been received. But the date of unhelpfully, the date was not mentioned as to when the CCMC was to be listed. But the reply was dated the 7th of June 2019. So a good anecdotal experience would demonstrate that the CCMC wouldn't be for quite a considerable time after that date. So it certainly wasn't an imminent hearing. And I'm afraid that there isn't any evidence that I'm aware of as to when that listing was. Just that the matter had been listed for CCMC.
Right, so that's the correspondence you wanted to show us.
Yes, well, I'd finally just turn briefly to the judgment in the court below. Behind tab 5.
Yeah. Bear in mind we've read it.
Yes, well, I will deal with
where you say the judge went wrong.
I deal with this in my my skeleton, as you will have seen at paragraph 31. I take no issue with the learned judge's statement of the facts, in that he recounted the correspondence correctly, and also no issue with the law as he sets it out in paragraphs 45 to 55. He notes Win and Bull, Goodwood Investments, and a number of the cases that are included in the authorities bundle correctly. The issue that the appellant takes is with the judge's findings at paragraph 56. And you will have seen in my skeleton, I make the submission that the learned judge fell into error by failing to consider primarily the intention to create legal relations, the legal effect of the subject contract qualification, as a distinct issue from the question whether there was a complete agreement. And
the impression I have is that the judge was not shown either Sherbrooke and Dipple or Cohen and Nestdale. Is that right?
That is right, Your Honour, and it's regrettable because perhaps had he, the decision would have been different. And so no criticism is made of the judge at all on that point. But it is right that they were raised as being two separate points by the appellant, i.e. subject contract as a legal concept and whether there was a completed agreement. And I'd suggest looking at the learned judge's findings at paragraph 56, that in reality most of these points really go to whether the parties were ad idem on all matters of substance, whether there were any significant obstacles to their agreement, rather than on whether they had agreed to be bound. So, for instance, at paragraph 56A, he says the only real issue in dispute was the sum to be ring-fenced to £140,000, which ultimately was agreed at £75,000. And I say, well, that's a question of what was in dispute as a matter of substance. That's a question not of whether the subject contract label applied or whether the parties intended to create legal relations through those emails. Then the same criticism is made of the findings at 56B and C. At B, there was express reference in the correspondence to full and final settlement, and all relevant discussions between the parties were about that, not a partial settlement. Again, that, in my submission, is a question of what had been agreed rather than whether it had been agreed to be binding. At paragraph
you say that in paragraph 56, what the judge is really considering was whether any agreement was or was not incomplete.
Yes.
And that's a different question from whether any agreement was intended to be contractually binding.
Yes. And looking at each of the points that he sets out in his subparagraphs, and when one reads through them, I'd suggest that it is clear that that is the question that he was addressing, notwithstanding the fact that he had set out the law relating to the subject contract qualification earlier on in his judgment. When it came to applying that law, the focus was on whether there was a complete agreement. The closest I would suggest that this paragraph comes to dealing with the issue that I've identified is just above subparagraph E on page 42, about just over halfway down through that paragraph. He says, I also note the way in which Mr. Sagar made reference contesting the action that in his statement opposing the application, he in fact used the term disagreement in relation to the position the parties had reached on the 11th of July 2019. Whether consciously or otherwise, I find...
Unconsciously or otherwise.
Apologise. Whether unconsciously or otherwise, I find that did reflect the parties' true understanding of the position, namely that the claim had indeed been compromised by agreement on the only remaining issue of substance, which was the division of the ring-fence sums. And it's possible to read this as a reference to the parties' understanding that the compromise was binding, i.e. that it was legally enforceable rather than just all of the terms had been agreed, because he says that the claim had indeed been compromised. But I'd suggest it's still mainly influenced by what he goes on to say on the only remaining issue of substance, i.e. that the learned judge was still primarily considering what terms had been agreed rather than whether they had been agreed on a legally enforceable basis.
Well, what I read this as saying is that looking at Mr. Sakar's statement in the application, therefore substantially post-dating of these events, he's made the judge thinks some kind of Freudian slip by using the word disagreement, thereby unconsciously or otherwise giving away the fact that
I think there's a transcription error there. I think what the judge said was this agreement rather than disagreement, because it really doesn't make any sense if one reads it as disagreement. And I think there's simply a typographical error in the transcript there. I don't know if my learned friend agrees.
I do. I'm grateful to my learned friend. It was a point I was about to raise, that my recollection of that hearing was that actually the judge was referring to the fact Mr. Sakar said in his statement he kept referring to the agreement or this agreement, i.e. the agreement that was reached on the 11th. And it seemed, and what I think it seems from this, certainly my understanding is that the learned judge was saying, well, Mr. Sakar's referring to an agreement. Clearly he thought there was an agreement, i.e. a legally enforceable agreement. I'd suggest that's a non sequitur. That he was using the term agreement, as indeed I have throughout making my submissions. It was an agreement, but it was an agreement subject to contract. The two aren't.
But which part of Mr. Sakar's statement is the judge referring to? Is that what we've got at supplementary bundle, paragraph 6, is it? There's tab 6.
Or if the court will excuse me jumping up and down, I think it's paragraph 12.
12.
The final sentence on page 93.
Right, reflects the belief, namely that this agreement was in settlement. Yeah, right. Thank you. So we can correct then disagreement. Yeah. Right, Mr. Skin.
Those are essentially my submissions. The only final point that I would make, unless there's anything arising or any questions, is the passage of Lord Justice Templeman's judgment that I set out at the final paragraph of my skeleton argument. Which, of course, also it's in Sherbrooke and Diffel, and also appears, if the court would like to see it in context, in the authorities bundle at page 10, behind tab 2.
Yes.
And you'll see it marked in black there, which is this passage. In my submission, that Lord Justice Templeman's observations here are entirely apposite. He notes that, in my judgment, the judge, with great respect, fell into the error which is abumbrated by Mr. Justice Brightman, namely of thinking that because parties got near a contract or conveyance, because parties assumed that they would go happily on until matters had become binding, therefore the subject contract qualification either ceased to have effect or was replaced by a new contract. That, in my judgment, is not the position. It is always the case that in subject contract negotiations, one side or both from time to time speak as though there was a contract or would be a contract. And that is because everybody looks on the bright side and thinks the sale is going to take place. The fact of the matter is that, for very good reasons, the subject contract formula enables one to see at once whether there is or is not a contract, either a contract exchanged or conveyance executed and delivered, or whether parties are in the negotiation stage. Once one gets away from that principle, then all is difficulty, and reliance on odd conversations and letters produces uncertainty in the law. If I may, I'd suggest that that is precisely what has happened in this case. The offer states quite clearly on its face that it is subject to contract. And in those circumstances, particularly in a context where there are professional solicitors on both sides negotiating commercial litigation, that it would be a very unusual case where only the clearest evidence to the contrary arose, that label wouldn't have the effect that it is understood to have at law. And it is for that reason that it's said that the learned judge fell into error, and that the judgment, unfortunately, does undermine the efficacy of that label. And so for those reasons, I'd invite the court to grant the appeal.
Thank you.
Unless I can assist further.
No.
Do you have anything more? Thank you very much, Mr. King. Yes, Mr. Monmouth.
Thank you, Lord. Your Lordship, your Lordships and your Ladyship will have seen from the core bundle that the matter, as your Lordship rightly identified, didn't proceed quite in this fashion before the learned judge. it wasn't the case that, as my learned friend says now, that Joanne Properties Limited advanced the case that the umbrella of subject to contract went up on, he says, looking at page 101, for the first time on the 29th of May. The point which your lordship identified when granting permission to appeal simply wasn't the manner in which the case was argued in the court below.
Yeah.
Now, of course, that doesn't stop my learned friend arguing it now. He has permission to argue it. But I hope the court can understand that the manner in which the respondent's case is put in this appeal has been informed by the skeleton arguments which we've received. And frankly, the exposition as to what these items of correspondence that predate the 11th of July mean is something which we're hearing for the first time today. That doesn't mean I don't have to deal with it, of course, and I will. But just to put it in context, that it explains why, when one looks for the learned judge's reasons on this point, they are scant.
Yeah.
And when one looks at the respondent's position, it appears to be meeting a different case. And the case that was met in the respondent's skeleton argument, and with all respect to my learned friend, it couldn't have been made clearer. We said in that skeleton argument, it appears to be the case that the appellant says one must look only at those 3 emails which my learned friend referred to. In relation to the respondent's notice, we made the point, of course, that the point wasn't made in the court below, and also made the point that at that stage it appeared to be the appellant's case that one looks only at those 3 emails. But if they were going to expand on that position, then we'd like an opportunity to respond, because, of course, it hadn't been raised before. So my learned friend has come to the court with a rather different proposition today. And it means that I have to address that in a rather different fashion. What the respondent's notice did was to seek to protect the respondent's position in the event that the case changed, that the appellant's case changed from the way it was advanced in the court below to saying that the umbrella went up at an earlier stage, and therefore, of course, it was necessary to consider whether, if indeed the umbrella had gone up, whether the parties, by necessary implication, had agreed for it to come down. And, of course, the manner in which it's put in the respondent's
Just to stop you there, I'm sorry to interrupt, it's quite so early. You accept, do you, that there is no express agreement to lower the umbrella?
Indeed.
So we are concerned then with necessary implication.
We are. Lord, if I could turn to the respondent's notice briefly, it's at tab 12. And the grounds are set out on page 153. And really, given the way in which the matter has developed, it's the second of those that's the most relevant, that on a proper analysis of the course of dealings, the parties had by necessary implication agreed that any subject to contract qualification should be expunged. So as your lordship rightly identifies, that's the point that we're arguing about. And the respondent's skeleton argument that was filed in support of the respondent's notice at tab 13, I regret you don't have a replacement version of that, which is fully referenced, but perhaps we can make do. In relation to the point that I was just making, could I ask you to look at paragraph 29 on page 167? Just to show that the respondent's approach has been consistent throughout. What we submit there is that A, the appellant does not advance a factual case, but the parties were negotiating under a subject contract umbrella prior to 11th of July. It's difficult to see how they could advance such a case, in particular given the nature of the offer made by the respondents in their letter of 19th of June.
And that's the purported Part 36 offer.
My lord, yes. And our case, accordingly, there was no such agreement. I mean, for these purposes, an agreement that negotiations were taking place under a subject contract banner prior to 11th of July, or if there had been, it must, by necessary implication, have been removed no later than the telephone conversation on the 11th of July. And that's the conversation which my learned friend referred to in relation to the file note from Mr. Irvin, recording his conversation with Mr. Goldberg.
That's the 72,000 offer.
Yes. It's really
But
perhaps...
why would it not have been reintroduced when Mr. Irvin follows that conversation with a proposal expressly said to be subject to contract, not to take the 72 on offer, but to ask for 75?
Lord, the question in my respectful submission is whether the parties are both operating on that understanding.
Why? Why?
Can
As my lady put to Mr. Kingham, if I make you an offer to buy something subject to contract,
Yes.
whether you intend to enter into a binding contract with me doesn't really matter. You can't, because I've made the offer subject to contract.
Well, Lord, that's right. If that is truly how it is to be interpreted.
Yeah.
My Lord, what I would like to take the court to is a relatively small period of time.
Right.
It starts on the 19th of July. Sorry, I beg your pardon, the 19th of June. And it is what the parties themselves referred to as the Part 36 offer. Now, we know they were mistaken in so doing. We know perhaps it started life as a draft in Mr. Irvin's inbox, which had Part 36 on it. By the time it was sent, it wasn't a Part 36 offer. It couldn't meet those criteria. But what is important, in my respectful submission, is that both parties treated it as such. They both called it a Part 36 offer. And there is reference to it being a considered offer, not the start of horse trading, although, of course, we've seen horse trading ensued, and reference to extension of the time for accepting it. And, of course, that's important in the context of Part 36, because were it a proper Part 36 offer, the cost consequences would or wouldn't flow according to whether it was accepted outside of the time for acceptance. So, my Lord, we have that on the 19th of June, and that's at page 111.
Yeah.
What we have subsequent to that, and my learned friend relies on this, of course, page 113, is Mr. Goldberg to Mr. Irvin. He starts by saying, I set out below the content of the email I sent to my client. It's obviously not the whole email, because it starts with the bottom line. One wouldn't expect that to be the starting point. But then he has, underneath the 4 bullet points, I had a very long reply out with the client for approval, but that has been superseded by your client's recent Part 36 offer. So there are 2 points to note. One is that it's referred to by Mr. Goldberg as a Part 36 offer and appears to be understood as such. And he says that has superseded matters. Because in my respectful submission, what happens from that point onwards is a bout of horse trading on the Part 36 offer, so-called.
Well, what he actually says is he's making a counteroffer with a compromise sum of 115,000, just above the word costs.
Yes.
And he does it in a letter saying without prejudice and subject to contract.
My Lord, he does. In purely monetary terms, we have a situation here where the starting point from Mr. Irvin, in a letter which is not expressed to be subject to contract and which couldn't be if it was properly understood as a Part 36 offer, says we want 80,000, you can have 60,000. The parties get to a final position within a matter of about 3 weeks, where the only difference to that is £5,000.
But the Part 36 offer, I was trying to remember what the cases say about this. If I make you an offer and you reject it by making a counter offer, just as a matter of ordinary contract,
Yes.
you cannot then accept the offer that you have rejected. Because the counter offer nullifies my offer. My understanding was, and I think there may be some authority about is that's not true for the Part 36 offer. That you can negotiate behind the scenes, as it were, not accept the Part 36 offer, and when those negotiations run into trouble, you can go back to the Part 36 offer and say, okay, I'll accept it. Is that right?
That is right, my lord. Yes.
So a Part 36 offer, as it were, stands alone or stands apart from the ordinary course of offer and counter-offer in correspondence, doesn't it?
My lord, it can do.
Right.
In my submission, what happens here is it becomes the framework for the discussion.
Yeah.
Because up until that point, there's been a lot of debate, and my learned friend took you to it, about really subsidiary matters, which end up being nothing to do with the final
Yeah.
negotiation.
Well, wouldn't it be more accurate to say it provokes a discussion? Not that it provides a framework for discussion. Because, as my lord has just indicated, and I think you agree, and I think the basis of it is that going back and saying I'm not accepting your Part 36 doesn't prevent the term of the Part 36 offer, which says this is open for acceptance for 21 days,
Yes.
continuing. So people engaged in litigation like this know that the fact of a Part 36 offer being on the table doesn't prevent them entering into subject to contract without prejudice or open discussions.
My lord, that's right. There could be parallel discussions.
And frequently are.
My lord, that may well be right. But in this case, and perhaps when I said it provided a framework, what I mean is that it was negotiation about one small part of the terms set out in that offer, which ultimately resulted in the agreement. And I'll call it the agreement, I appreciate what my friend says.
But it is expressed from the outset as a counteroffer, as we see on page 113.
At that point, Lord, yes. But when one goes on to see what happens after that, the crucial point is that the offer of 72,000 is made. It's not understood as an offer in the first instance by Mr. Irving. Perhaps if I can take the court to that exchange.
121.
121, I'm grateful. So after a bit of back and forth, on the 10th of July, Mr. Goldberg writes, under the banner simply without prejudice save as to costs, as my learned friend identified, I need to take instructions on the agreement you refer to below. That's a reference to a possible settlement of the other action, what's been referred to in some of the correspondence as the EESL action. And I'll come to that in a moment because it's tangentially relevant because of a point my Lady Justice Rose mentioned. Mr. Irvin has said this is something that he understands, and perhaps I'll make the point now that Mr. Irvin was not instructed in the EESL action, and of course it's a different corporate party involved.
I'm sorry, I'm a bit lost. I thought you were looking at 121 and Mr. Goldberg's email.
122, my lord. I'm afraid
122.
I was endeavouring to explain what Mr.
I
Goldberg meant at his second point. I need to take instructions on the agreement you refer to below.
Oh, I see. That's ESL have reached an agreement with Mr. Medaille.
That's right. Yes.
Yeah.
So, my lord, 2 points, if I may as well make them now, about the ESL action. Different parties and different representation. So any suggestion...
Are they related parties? That seems to be...
There is a relation between the parties, but certainly any suggestion that Moneything or Mr. Irvin were trying to settle those cases by the back door in this action is, with respect, not sustainable. So on the 10th of July, with no mention of the subject to contract umbrella at all, Mr. Goldberg makes an offer of £72,000. He also asks for an extension of the Part 36 offer. Now, the court, I suppose, could conclude that he's trying to keep two parallel tracks open at that point. One a subject to contract umbrella, one under a subject to contract umbrella, one not. But in my respectful submission, that reads rather too much into it. And in my submission, the correct analysis is that he recognises that the parties are discussing the terms set out originally in that, the offer which has been described as the Part 36 offer, and he's trying to keep that open. So there's the point about horse trading in the email above, and then the exchange on page 123. Mr. Irvine follows up his initial email of 8/11 on the 11th of July with one at 10:22, saying, obviously I'm duty bound to take instructions on any firm offer made by JPL to settle. And again, no suggestion of the subject to contract umbrella applying there. Mr. Goldberg says at 10:26, I made an offer that I assume has been rejected, see Roman 4 below, which we've already seen. And then we have a telephone conversation. And as a lady rightly identified, the parties got fed up with being at cross purposes on email and had a telephone conversation. Now, a feature of this case is that the only evidence you have from the participants in this negotiation are from Mr. Irvine, who's included attendance notes and so on, and Mr. Saker. And it was interesting to hear my learned friend say, please ignore what Mr. Saker has exhibited in his witness statement, because that's how we have that document. The document at page 128 is something that Mr. Saker has supplied. Of course, it's not something which we'd be entitled to see. It would, on the face of it, be privileged. But he's chosen to waive privilege in that regard. And it is a document which I submit is relevant for a number of reasons. But before I get to that, my learned friend says, well, one can read this in lots of different ways. Well, the clear reference is Mr. Goldberg confirmed that this was a firm offer with instructions from JPL to make to Moneything, and if accepted, that was the matter concluded, save that we still had to work out the mechanics of how the funds got released from the ring-fenced sums. So the only qualification, and there is a qualification, so Mr. Irvine has reproduced it faithfully, the court can be, in my respectful submission, confident, but the only qualification is that we still have to work out the mechanics of how to release the funds. And that's a matter which the judge in the court below didn't find to be a bar to there having been a concluded settlement, and in my respectful submission was right so to find.
So you say that that question goes to whether the agreement was complete.
Yes. And of course, I think there's a reference earlier in the exchanges to it not being beyond the wit of man to agree how that might happen. And,
yeah.
So in my respectful submission, that is a very significant conversation. It is something on which the court only has that evidence. There is nothing from Mr. Goldberg in this case. And importantly, and I'll come on to it in a moment, there's nothing from Mr. Saker to suggest that the interpretation which I invite the court to take of that conversation is wrong. And this is contemporaneous. There's no reason why the court can't consider what was being said by Mr. Goldberg to his client between the conversation which took place on the telephone at some point before 11:20. We don't know. In fact, I suppose we can say that it must have taken place between 10:26 and 11:20, that being the timing of the two emails. But before the agreement is communicated, so during the course of the negotiations, there is an exchange between Mr. Goldberg and Mr. Saker in which Mr. Irvine's email of 11:20 is sent. And we have that at page 128.
Yeah. Shall I accept?
Yes. Lord, this is where I perhaps I overstate the point. But Mr. Goldberg himself says, see, having a good relationship does sometimes work. I've saved you £5,000. And that's what happened. There was a horse trade which went from £80,000 to £75,000.
Yeah. So, I mean, what Mr. Goldberg sends Mr. Seekar is Mr. Irvin's email,
Yes,
which is attached to the bottom of his own,
indeed.
headed subject to contract. That's what's sent to Mr. Seekar.
That is right, yes. But it's instructive that Mr. Seekar's reaction is the reaction of a client who says, yes, it's agreed, and thank you. Obviously, you're used to reluctant clients, but it's an annoying pill to swallow that the crooks get anything. But as a rugby friend of mine used to say, we'll play with a bigger ball next time. That's an analogy which has been lost on all the parties for the duration of the agreement. I would have thought a bigger ball in rugby would just make the scrummaging more difficult, but there we are. And he goes on to say, please let me see the settlement terms. We need our bit of the 140,000 released to us ASAP. Now that, in my submission, is not consistent with a client who thinks this is an agreement which has to be negotiated and settled in writing before it's binding. And just as Mr. Irvin, it has to be accepted that he understands what subject to contract means, well, Mr. Saker's a member of the bar. He says so in his witness statement. And there's nothing in this to suggest that this is the first step in an at least two-stage process. Mr. Saker is looking forward to a cheque. And why would he need to say, we'll play with a bigger ball next time, if this wasn't the conclusion of this particular skirmish? So in my submission, what he has disclosed there, for whatever reason, is very illuminating as to the manner in which he was addressing, as the person giving instructions to Mr. Goldberg, the matter. My Lord, when one looks at his statement, if I could ask the court to turn that up briefly, at tab 6 in the supplemental bundle. Now, there may be many reasons why Mr. Goldberg hasn't provided a statement, and there may be many reasons why Mr. Saker decided that he was going to do so. I can't speculate. But it is important in my submission to see what he did say. And at paragraph 11 on page 93, he says, understanding, as the individual giving instructions on behalf of the claimant, was that the settlement discussions between Mr. Irvin and Mr. Goldberg, Gisby Harrison formally for the claimant, only related to the division of the ring-fenced sum referred to in the agreement of 18th of January, and not the settlement of the entire claim. It was the claimant's intention that the claim would continue, but an amount of money would be released to the claimant straight away, implementing the mechanism contemplated in that agreement. Now that, I think I've referred to it perhaps slightly rudely in my skeleton argument, as absurd, because every reference, whether or not we're talking about a subject to contract agreement, we're certainly talking about one in full and final settlement, which involves the dismissal of the claim. So for Mr. Saker to say that is very surprising. But it's almost as much what he doesn't say, because he doesn't say, as the individual giving instructions on behalf of the claimant, I had told Mr. Goldberg only to discuss this matter, only to discuss settlements subject to contract. Nowhere does that appear in his statement. And it's not Mr. Goldberg's decision, it's the decision of the client, suitably advised, of course. But nowhere does Mr. Saker say those were his instructions. Where he talks about subject to contract, it's at paragraph 22 on page 95 and over the page into 96. He talks about the draft consent order. And in the second paragraph says, I note that much of the correspondence exhibited to Mr. Irvin's statement is similarly labelled subject to contract, presumably precisely because Mr. Irvin and Mr. Goldberg wished to be able to negotiate certain elements of the settlement in the knowledge that no binding agreement will be formed until formalised in writing, capturing all the terms, and in this context signed as a consent order. But he doesn't say those were his instructions.
Does it matter?
Well, my lord, given that there's nothing from Mr. Goldberg, in my submission it is very illuminating that he does not, in the documents he's chosen to disclose, and in the statement that he's put in, say that's what was happening.
Well, but aren't we supposed to interpret the exchanges between the solicitors objectively?
My lord, yes. It is an objective analysis, but that includes, and I think my learned friend rather got into a mix-up with objective and subjective, because of course, if somebody says after the event, this is what I meant, well, that may well be coloured by partiality, and it may, as my Lord Stuart-Smith said, it may simply be wrong.
Yeah.
But what we have here, in contradistinction to that, is contemporaneous evidence of what Mr. Saker and his solicitor were doing and saying about the agreement which they were just about
But
to
it never
indicate
crossed
their
the line.
consent.
It never crossed the line. What at the time that the agreement upon which you rely happened, this discussion between the appellant, client and solicitor formed no part of the discussion between the parties. So how, on an objective basis, can it have any influence?
My Lord, what it's an indication of in my submission is the impression, the understanding that Mr. Goldberg had of the negotiations that he was carrying out. Because what my learned friend says is, well, we've got offer acceptance and a subsequent letter all say subject to contract. But when one unpacks that, yes, there's an issue with the offer. That contains the word subject to contract. But in relation to the response, it's very difficult to say that Mr. Goldberg turned his mind to the issue of subject to contract in those circumstances.
Well, what would he have written? You say he wrote agreed, and that expunges the reference to subject to contract in the title of the email. So what do you say he should have written to make it clear that, assuming, which I think we're all agreed, that he can't actually simply create a binding contract if the offeror isn't offering
Yes.
to be bound, what does he write?
Lady, can I be clear about the way that I'm putting the point? I don't say that simply by agreeing one can lift the subject to contract banner. I think that was advanced in another of the cases and rightly said to be an incorrect proposition. What I'm inviting the court to do is to look at that lengthy, well, it's not that lengthy, about 3-week period, and to conclude from that in fact it was not the party's intention that the subject to contract banner was erected over that discussion.
But your difficulty surely is that if he'd applied his mind to it in the way that you suggest and thought that he was concluding a final agreement and a legally binding agreement, he should have said, agreed, but I note you headed your email subject to contract. Surely that's not the basis upon which we were negotiating. Please confirm we now have an agreement, a legally binding agreement.
He could have done that.
So as soon as you start going down this line of subjective intention and so on, you run straight into a brick wall in the terms of his response, don't you?
My Lord, in my submission, one has to look at it from the point of view of the offer that was made was £72,000, not said to be subject to contract. That in itself responded to an earlier offer of £80,000, again, not said to be subject to contract. It's a bit of a leap to suggest that Mr. Irvine was content to make the £80,000 offer without it being subject to contract, but then had changed his mind and imposed that umbrella again at the point where the figures were simply £75,000.
So we should just ignore the heading in Mr. Irvine's email? Is that what you're saying?
My Lord, I invite the court to look at the course of negotiations as a whole.
But that's what it comes to, isn't it? You're saying ignore the heading in Mr. Irvine's email.
My Lord, yes. Ultimately, because as with cases such as the Gyre House decision, there are examples where the court's been prepared to conclude that the subject to contract umbrella was not in the minds of the parties. There's an extract in Jai House. Perhaps I could take your lordships to that. It's at tab 5 in the bundle.
It's true that there are cases, exceptional cases, where the court has disregarded subject to contract. I think it's a decision of Mr. Justice Goff, if I remember, called Michael Saviour or something, when a contract was put out for formal tender and somebody purported to tender subject to contract, and he said, well, that doesn't mean anything. If you're responding to a tender, it's intended to be binding. You can't alter that.
Yes.
But that's a very exceptional case.
Well, my lord, this is a case which has some very exceptional features in my submission, one of which is the court knows what the exchange was that happened on the very day at the moment of acceptance.
Yeah.
My lord, if I could just briefly turn up the Jaya House decision, which is at tab 5. It doesn't have a head note, unfortunately, but the brief facts. There was a complex action which even the judge in that case chose not to recite. But he sets out at paragraph 5, the issue before me is whether or not the action and an associated action was settled in negotiations between Mr. Claimant, counsel for the claimants, and Mr. Trion, the defendant's solicitor. And at paragraph 8, all of the terms were agreed so far as I can see. The primary question is whether or not they were agreed on a binding basis or on a subject to contract basis. And on paragraph 13 over the page, the learned judge recited the issue again. As I've said earlier in this judgment, the parties were in agreement as to the terms as a result of the lengthy negotiations which took place on the 29th of June 2009. The issue is as to whether or not those negotiations took place under a subject to contract umbrella so that the results are agreed but not yet binding. If one turns over the page, I've highlighted all of the occasions, or I'm about to highlight all of the occasions on which...
Sorry, you highlighted.
I beg your pardon, Lord, I haven't in this judgment. I've highlighted them in my copy. I'm about to mention them. Starting at paragraph 17, not quite the start of the discussions between the parties in that case, but you'll see reference to an email sent on the 24th of June. The subject heading is marked without prejudice, I beg your pardon. And when one looks at the quoted section, the final phrase, the terms of this email should be treated as subject to contract terms. Paragraph 18, there's another email recited at length. This does not represent an offer capable by acceptance of becoming a contract or settlement. And towards the bottom of that paragraph, the subject was described as being without prejudice and subject to contract. On the 26th of June, proposed orders drafted. On Monday the 29th of June, there's an email marked without prejudice and subject to contract. Again, paragraph 20, a further email on that date, timed at 16:48, headed without prejudice and subject to contract. And the final sentence of the letter needs to say there's no settlement until all the documents are executed, sending that to counsel on the other side, paragraph 21, with an email marked without prejudice and subject to contract. And the learned judge goes on in that paragraph to refer to a series of further discussions. But the conclusion that the court reached in that case, notwithstanding all of those references to discussions taking place subject to contract, was that face-to-face discussions between the parties were not carried out under that umbrella. And in that case, the court concluded, starting at paragraph 36, that it should be necessarily implied that the restriction had been lifted. So one can have a situation in which there's a very great weight of very clear indications that the parties are negotiating subject to contract. And yet the court is prepared to conclude on an analysis of the whole of the transaction, the whole of the course of the negotiations, that banner's been lifted. And importantly, at paragraph 41, a party then cannot seek to unilaterally re-erect the subject to contract umbrella.
Well, that's on the assumption that there's been a binding and legally binding contract concluded.
My Lord, yes.
You can't do it retrospectively.
Indeed.
Well, that's
So
right.
that the point in relation to the letter of the 24th of July is if there had, in fact, been an agreement, as I invite the court to conclude there had a binding agreement, that it couldn't be unilaterally effected after the event.
On the other hand, if you were negotiating on the 10th of July, not subject to contract, there's nothing to stop you saying on the 11th of July, subject to contract, and then anything going forward from there is subject to contract.
Yes, my Lord, that's right. The question is, was that actually what the parties were doing in this case?
That's what they said.
Well, my Lord, what my learned friend relies on is one line in an email subject heading. The response in my respectful submission goes nowhere because it is simply the automated response. And when one looks at the whole course of dealings over that period of time, the implication, the necessary implication in my submission is that the parties were no longer negotiating subject to contract. And the 2 points of evidence that I principally rely on are the conversation which took place on that same day. Because if it's right that the court has to conclude that Mr. Irvine executed what on my submission is a volte-face on that day, over the course of about an hour, in that he was having a discussion on the telephone with Mr. Goldberg on the basis that the offer had been put to settle the case, that was it. And then he put a counter offer subject to contract. Well, he didn't do so very clearly in my submission. Not with the degree of clarity that one sees, for example, in the Jai House case.
How can you be more clear than stating at the head of your email subject to contract?
Well, my Lord, in this case, by saying something like, I know that our discussions this morning were on X basis, I can only put an offer to you on Y basis.
But why do you say the discussions were not on a subject to contract basis? You say that the offer of the 72,000 on page 124 by Mr. Goldberg.
Yes.
You say that that was not on a subject to contract basis. So that if you say that if Mr. Irvine had replied yes instead of no,
Yes,
that would have been a binding agreement.
indeed.
Right. And that thereafter he puts forward 75 after the phone conversation.
Mr. Irvine puts.
Yes.
Yes.
And that should be, we should ignore the insertion of subject to contract because that is a response to a firm intending to be legally bound if accepted offer of 80,000.
Of 72, lady.
Sorry, of 72.
Yes.
Yes, the 10% off the 80,000.
Yes.
I see.
And
So that's how you put it.
indeed, that's how I put it. There was another point which my learned friend opened on in relation.
Just wonder, Mr. McDonald, do we need to look at Mr. Justice Peter Smith's reasons for why he thought that the subject to contract umbrella had been lowered?
Lord, I'm happy to take you to.
He says he deals with his reasons at paragraph 38. First is that Mr. Claimant was not alive to the subject of contract restriction. I'm not quite sure what he means by that because I think Mr. Claimant had been the recipient of some of the emails. Secondly, he says he had ostensible authority as counsel to negotiate a final settlement. Thirdly, he and Mr. Treon were anxious to achieve finality that night. Then the parties acted as if a final settlement had been achieved, and Mr. Claimant took another brief. And fourthly says that when parties shortly before the trial instruct their lawyers to conclude a settlement, it can only be on the basis there is an agreement that the subject to contract umbrella has been lifted.
My Lord, yes.
Those are very particular reasons, aren't they?
My Lord, they are. They are. And of course, every case, as the authorities say, has to be decided on its own facts, with consideration of all of the relevant matters. But in response to the suggestion, just ignore it. Well, there are cases in which, for good reason, it is ignored.
Yeah.
And this is just such a case.
Right.
The point on which my learned friend opened on the law in relation to events subsequent to the agreement, could I just briefly take the court, because it may be a matter that needs to be rehearsed in the judgments in due course, just briefly to the Gibbs and Lakeside case, because the facts of that case perhaps point up very clearly why Mr. Justice Arnold respectfully disagreed with the way Mr. Justice Lewis put it in the Sun Microsystems case. At paragraph 16, that is where Mr. Justice Arnold says, where I differ from the learned, I beg your pardon, this is at tab 9 in the authorities bundle, page 120. Where I differ from the learned judge is with respect to his approach, the court was restricted to consideration of the two communications of 1st of March and 8th of March. On the contrary, with all due respect to Mr. Justice Lewis, it seems to me to be well established that in considering whether an agreement has been concluded, the court is entitled to have regard to all the communications between the parties. And there's a reference to chitting. If further authority for this proposition is required, it can be found in the judgment of Lord Clerk, giving the judgment of the Supreme Court in Mulcahy, which we have, where Lord Clerk approved the well-known summary of the relevant principles given by Lord Justice Lloyd.
I'll say that was my understanding.
Yes. My Lord, when I referred the court to Teether, it was in part so that the court had, I hope, a helpful summary without needing to go into all of the authorities that back up those propositions. But also because the learned judge in that case perhaps slightly sat on the fence, saying he didn't see why he should disagree with Mr. Justice Lewis, but just in case, it would only be matters which were of particular relevance, which impacted on the conclusions to be drawn. And it may be that that is the correct approach. I have criticised the appellant's approach to events post the agreement because it is extremely partial. They want the court to pay attention to parts of the letter of the 24th of July and not other parts. The part I would rely on, of course, being the part which says, we take it that you agree that there's been a settlement. And they also perhaps want the court to ignore that which the learned judge referred to, which we've already discussed, in relation to the conduct post the agreement, post the sending out of the 24th of July letter. I don't go as far as to say those matters are of great significance.
What is the conduct? It's basically silence, isn't it?
Yes, silence in the face of being asked the question.
Right, and the judge says he can't speculate as to why they're silent, and then goes on to speculate as to why they're silent,
I think
guessing what is going on between the
I think he
solicitor
refers to
and
the
the
silence
client.
as deafening or something.
Yes, speaks volumes, I think.
Speaks volumes.
Was his
Lord's
phrase.
absolutely right. Well, he may have felt it did. Certainly it wasn't put to him on the basis that what happened afterwards was conclusive in any way. And in my submission, the way perhaps to resolve the authorities is to say that in certain cases, certain matters post-events may well be very informative as to the nature of the nature of the compromise or not. And I was just going to take the court to the facts of the decision at tab 9, because in that case, the party that was alleging that there had been a settlement, if one looks at paragraph 17, Mr. Justice Arnold says, in the present case, if one goes on to consider the subsequent correspondence, it seems to me the judge's conclusion as to the effect of the email of 8th of March, that is, that it was a counter-offer, not an acceptance of an original offer. What happened was as follows. On 9th of March, the appellant, the party trying to rely on the compromise, replied to Mr. Branch, saying as follows, and in the short extract, second sentence, your client, the claimant, has not accepted my offer. So in those circumstances, on the very next day, the party trying to say that there'd been an agreement had actually written an email in which they said there was no such agreement.
Yeah.
So one can well see why Mr. Justice Arnold might have felt that was of some assistance. But there's nothing like that in this case.
In a way, it's surplus, because if that letter that you've just taken us to had not been sent, it would still have been open to a party to make the submission. There were these two terms which were not accepted. They're important. There's no agreement.
Indeed. Yep. I think it was backup, I think, perhaps be the colloquial way of
I
describing
think reinforced is
Yes.
as high as one can put it.
Unless I can assist further, that's the respondent's case.
Thank you very much, Mr. MacDonald. Yes, Mr. Kingham, any reply?
Only 2 points very briefly, Lord. Just to clarify in particular what has been argued below and what has been advanced as the appellant's case and what hasn't. To clarify, it was expressly argued below that the subject contract label applied, and the learned judge did cite Win and Bull and Goodwin Investments authorities to that effect. So it's not the case that the appellant's changed its case on appeal in any way. It's simply now relying on a further authority as identified by my Lord Justice Lewison in granting permission. So it's not accepted that this is somehow changing the approach. It's simply building on it and adding to it in the course of the appeal. Similarly, the criticism is made that now the appellant relies on the full course of correspondence, whereas previously it did not. I think that's an unintentional mischaracterization of what the appellant's case has been, especially below. It has never been the case that the appellant sought to argue that other correspondence was wholly irrelevant, or that it should be disregarded, or that the court shouldn't take a look at it. The appellant's case was just quite simple. The offer and the acceptance both said subject to contract, and there isn't really much use or need to look at anything else. Nothing else particularly assists. However, having then been criticised for essentially cherry-picking these two emails, the response is to take a look at that correspondence over the whole course of dealing, and that is what has been done today. So I resist the suggestion that the appellant has somehow changed its case, or that it's evolved in an unusual or unexpected way today. The other point was just in relation to the Jaya House case that was discussed by my learned friend. And in particular, it's important to note that that was an exceptional case, as Mr. Justice Peter Smith later said himself. There is, unfortunately, where he says that is not included in any of the authorities, but there is reference to it at tab 8.
Judge Pelling says that.
Yes, precisely, citing Mr. Justice Peter Smith saying the same thing. And it was also a case, of course, that was factually quite different to this. The trial in that matter was listed in a 5-day window commencing on the 29th of June 2009. And the negotiations had started by email on the 24th, only 5 days before the listing window was due to commence. And in fact, then continued into the night, past midnight on the 24th. And Mr. Justice Peter Smith did place considerable emphasis on the fact that this was very much a last-minute settlement negotiation, that the window for settling it was closing rapidly. And so that in those specific circumstances, it was necessary for those negotiations to have any effect, for the subject contract label to be expunged by necessary implication. But there is, of course, no such urgent need in this case. And so on that basis in particular, I'd suggest that Jaya House can quite easily be distinguished on the facts. Unless I can assist any further.
Thank you very much, Mr. Kingham. Well, thank you both for your interesting arguments. We will reserve our judgments. You will receive a draft in the usual way, which will be your opportunity to correct our spelling and grammar, but not our reasoning. We would hope that in the light of the draft judgments, you will be able to agree a form of order disposing of the appeal. If you can't agree the form of order, please make short submissions in writing and we will simply decide one way or the other. There will be no need for an attendance at any hand down. I expect the hand down will be remote, but it may not be. But even if it's not remote, you need not attend. Thank you both very much.
Thank you.
All right.